Good afternoon. Welcome to episode 52, which is our last and final episode of 5 reasons not to harm your loved ones during quarantine. The get out of jail card um, has officially been distributed, and so we will continue with the series, but it will be under a different name beginning on Monday. And our first uh, show in the new series will be focusing on IEPs and compensatory education for students who did not receive their free and appropriate public education during the stay-at-home order. This is really going to be a very, very relevant topic for all students who have accommodations or supports in school. And I want to make sure that you're all armed if you are in that situation to help your kids before they go back to school, especially since we don't know what going back to school is going to look like. So, um, but today we are going to talk about judgments of divorce and how to end a divorce. As we learned a couple of days ago, divorces with children have a 6 months waiting period. Divorces without children are 60 days. That the time limits can be waived under certain circumstances, such as closing on a sale of real estate or some other special instances that have to do with a devaluation of the property if you were to wait. Excuse me. Um, there are two different kinds of judgments of divorce. Actually, I guess there's three, but two main kinds. The first one is a consent judgment of divorce, and that's what we're going to spend most of our time today talking about. And that's basically when you have two people who are involved in the divorce litigation, um, and the two parties come together and agree as to how they're going to untie the knot, how they're going to divide their assets, how they're going to handle parenting time if there's children. And it could be through all different kinds of processes. They could have had mediation to come to that settlement, they could have had a collaborator to come to that settlement. And so, um, regardless of the process, the way it ends is the same, and that settlement will be put into a judgment of divorce, or the settlement may be put into a settlement agreement that's incorporated by reference into the judgment of divorce. Um, the other kind of judgment of divorce would be a consent judgment of divorce. That means you agree to the judgment, but where there are no children. Okay, those would be like the two that are kind of treated the same. The third kind is what we call a default judgment of divorce. A default judgment of divorce is a judgment of divorce that's entered by one party when the other party has failed to answer the complaint or participate in the proceedings. So remember, many days ago, we talked about how an answer to the complaint has to be filed within 21 days of service of the complaint. If someone does not file an answer and does not participate at all, then the person who filed the complaint, because we're a no fault state, can go into court and say, I want to be divorced anyway, and here's a proposed judgment. And in that proposed judgment, it may, give the person who did answer and who wants the divorce basically whatever they want, because the other person didn't participate in the litigation. There are time deadlines and you have to ask the court permission to enter a default, and then you present the proposed judgment. The other party who didn't participate gets a lot notice each step of the way. And so it's different procedurally, but the content of a default judgment is pretty much the same as a consent judgment. It's just how it's entered that's different. So, in talking about consent judgments, there are provisions that are in there that are required and are in every single divorce judgment, and there are provisions in there that are unique to each case. Um, and so the pretty much it starts with the mandatory clauses, and that the mandatory clauses have to do some custody ones. There are at the statutory basis for the divorce, which is the breakdown of the marriage relationship to the extent that the parties are not going to reconcile. Um, then there will be, uh, at the end there are signatures. Only the plaintiff needs to go to court, and and then it's called a pro confesso, is what the hearing's called, or a pro con. And at that juncture, the plaintiff and the defendant, if the defendant appears, will have to put on the record that they've lived in Michigan for over 180 days and that they've lived in the county for over 10 days, that they filed the complaint, that the contents of the complaint were true, they remain true at this date, that there's a breakdown in the marriage to the extent that if the judgment of divorce was not entered, there aren't any circumstances that the parties would come back together and live together as husband and wife. Um, it, they have to confirm if there are minor children, if there are minor children in the marriage, that they're identified, and then the settlement can be put on the record. There as well, it would entail custody, parenting time, and support. If there were children, it would just really be property if there were not children, and that the parties understand that the settlement it could be better than what they would have gotten if they had litigated and had a trial. It could be the same as what they would have gotten if they had a trial, or it could be worse. And they have to put that on the record that they understand that. If one of the parties is going to change their name, that also goes on the record. And then this is the tricky one. In some courts, the judge does not want this question to be asked, but in others, the judges do, and that is whether or not the female, if there is a female, is pregnant. And as we talked about yesterday, there is a presumption if people are married and one of the parties is pregnant, that the other party is the father or other mother. And so because of that, that's why it's established. However, the in the in the complaint, it will say whether or not one party is pregnant, and some judges feel that it's unfair to, when you've already acknowledged that the content of the complaint is true, they find it unfair to ask the question in court again and find it discriminatory. So some judges want that question, others do not. It's just depends on what courtroom we're in. So some of the mandatory language that must be in a judgment of divorce with minor children is that a statement that the marriage is dissolved. You have a statement about any retirement assets, such as, and it's the Employee Retirement Income Security Act, which is ERISA for short. There'll be statements about beneficiary designations, financial accounts. There'll be a statement of pension rights. There will be, if there's custody, the mandatory, if it's with children and there's custody provisions, it's required that there's a statement that the legal residence will not be changed unless the court is notified or unless Section 11 of the Child Custody Act is complied with. There'll be a statement defining legal and physical custody. There will be a statement about domicile, where that child lives. There will be a statement whether or not the friend of the court is involved. If the friend of the court is not involved, we have other forms and paperwork that we have to also submit. There will be a specific or a reasonable parenting time schedule and what the contents of that schedule are if it's specific. There must be the provision that we talked about yesterday that during parenting time, the child will not be taken to any country that's not part of the Hague Convention pursuant to the civil aspects of International Child Abduction Act. Um, there will be child support provisions in there. It'll outline the financial terms of the child support, the duration, the amount, the anticipated date that the child will graduate from high school, whether or not they will be over 18 at the time. All of that must be in there. There will be another order called a uniform support order that is entered with the court, and that is basically the child support amount being ordered and how it has directions as to how it's going to be paid and processed and distributed. If there's uh, 4 kids at the time of the divorce, and then it would have on it that when the eldest child aged out, the second child's amount, when it was just 3 kids, that amount would be X, and then if it's 2, it would be Y, and if it's 1, it's Z, and that's all spelled out and entered with the judgment of divorce. If there's any spousal support, or if spousal support is barred, will also be in the judgment of divorce and is mandatory language that it be in there. It also has to indicate if it's modifiable or non-modifiable. It has to, if it doesn't say, then it'll be reserved to that party. If it's non-modifiable, then the modification is forever waived. So you can't go back if it's non-modifiable under any circumstances. If there is and you can set spousal support either at a term of years as a lump sum, or you can make it a term of years with some conditions. If the condition could be that the recipient of the spousal support gets married, then the spousal support obligation is extinguished. It could be that if the receiving spouse has an income of over a certain amount, then the the spousal support is modified to a lower amount or extinguished. So there's all kinds of things that can go into the language in the spousal support section, but you do have to have it in there. You also have to have a section in there that talks about dower rights. Our statement in there about dower rights and a waiver of the dower rights, and that goes back to common law, and it was that sort of big gift that dads gave to husbands for marrying their daughter, and so we need to have a waiver of dower rights by the husband in the judgment of divorce. It has to identify all real estate, including the legal description and the common address. It should identify all retirement assets, and specifically if there are survivor rights or beneficiaries. And it also, if there are retirement assets, then we need to have another order prepared, which is called a quadro if it is a non-government entity or a non-military entity, or it's airlines, aviation. They have a different plan as well. So so what this other order is it basically it sets the value that the receiving spouse is to get, and it indicates what that amount is, how it's to be distributed, what the penalties are if it's withdrawn before the person is of a certain age, or there's penalties if the earning spouse does not retire or takes an early buyout or different conditions with the earning spouse, the things that the recipient spouse can that can be triggered for that person to preserve their interest on or get their interest paid. So quadros are very confusing. Um, that is something that if someone, and we figure it all out and we put it in the judgment of divorce, we actually contract out the person who writes the actual quadro itself, which is a qualified domestic relations order, because it has to match the language of the specific plan and it has to comply with each plan's specific requirements. So this saves our clients tons of money by us using a contract source to do that order. Any other uh, property rights that either party have should be clearly and fully defined. If they're, and as well as any assets and liabilities. If there's credit cards with joint debt, who's going to assume it or how is it going to be paid off? Um, if there should also be a consideration of taxes. For example, if you get divorced in July, how are you going to file the taxes for that year in which you were only married for half the year? Jointly, uh, unmarried? Are you going to do it, or will you do it separately? Or you do it individually? Had a household? So all of that needs to be figured out and put in the judgment accordingly. There should obviously be something in the judgment that says that it's being entered into by consent and voluntarily, and no one is aware of any other promises, inducements, or coercion or threats to enter into the consent judgment of divorce. There should be a statement that upon dissolution, any temporary orders or interim status quo orders are extinguished because the issues that were the subject of them should all be taken care of in a final determination that is in the judgment of divorce. And then there should also be a statement that releases the attorneys, or if the attorney has a lien for their fees on their particular client's uh, half of the property division, that language would be in there. And otherwise, there would be a statement of that it's a final order and that it closes the case. So that is pretty much like the quick down and dirty of what has to be in a divorce. Um, it is the final document that's required to complete a divorce proceeding. Uh, in many cases, the the pro con will occur, and then the court will give you 21 or 30 days to actually submit the written judgment. If the written judgment isn't submitted, the case gets dismissed, and you have to start all over again, unless you go back to court and say we need more time, which the court may or may not give you. Um, there are, as I said, you must comply with the time limits. All the necessary documents have to be filed. There also has to be a record of divorce filed, which is just basically the information, the addresses, the dates of the birthdays of the kids, when the different orders were entered. That is filed and sent to Lansing. Um, Other things that can be included in a judgment are, life insurance. We didn't really talk about that. You can include personal property. It can be furniture. It can be the pots and pans. It can be the inherited diamond brooch. It could be the stamp collection, the baseball card collection. It could be the Tiffany lamp. It could be the TV. That can all be included or not included depending on what the parties uh, agree on. Uh, and the only other thing, things that I would say are not mandatory to be put in a judgment of divorce. You don't have to have the tax statement. Um, we find it easier to include it because it forces the parties to contemplate how that's going to happen instead of, especially if it's an acrimonious divorce and it took like a lot of effort to get to the agreement in the first place. We certainly don't want to have to be going back and like dealing with a disagreement on how the taxes should be filed 6 months, 8 months, a year later. And then the other thing is the inalienable rights. And these are rights that really belong to the children. And it's that their parents will cooperate with respect to the child to advance the child's health, emotional, and physical well being, and that they will give and afford the child affection of both parents and a sense of security from both parents. And neither parent will directly or indirectly influence the child or prejudice the child against the other parent. Um, and then it says that the parents will encourage and promote the relationship with the other parent. And basically, this is a safety valve for parents to play nice. And it is optional. It doesn't have to be in there, but it is in a lot of circumstances we do put it in there because they need it to be in there as a little reminder and to give one parent some vehicle to if they're enforcing the judgment to secure and maintain their bond with their children. Um, there, other optional provisions can be where the child is going to attend school, what school district it will be in, if it's going to be private school, who or what proportion the tuition is going to be paid, who's paying for the books, who's paying for the extracurriculars, who's paying for camp, who's paying for college, who's paying for the graduation party, how are we going to deal with bar mitzvahs or confirmations or things like that. Um, a lot of times people put in that neither party shall disparage the other party or their extended family in the presence of the minor children. Um, there can be provisions in there if one parent is taking the child on vacation or out of state, or how they notify the other parent of where they're going, an emergency phone number, etc. There Each party shall be available via working telephone um, when the child is in his or her custody, and they must answer it. And yes, we do have to put that in um, because a lot of people just want their parenting time and they don't want to deal with the other parent. Because remember, if they were enjoying dealing with the other person, they'd probably still be married. So that's why this is critical that that there's a working phone, in case the child wants to talk to the other parent, or in case there truly is an emergency. And sometimes we have to include that neither party will have an unrelated person of the opposite sex or same sex spend overnight when the children are present, except for the children's friends who would be allowed for sleepovers. And we always want to facilitate the same social life and interaction at both parents' homes. So, um, another provision that can be in there would be if there's dependency exemptions, if one parent is no longer going to be on the health insurance, there can be a provision in there that says that the other parent will cooperate in providing the forms and contact information so that the party without the insurance at their own expense can continue their insurance. There could be a provision about attorney fees. There could be a provision about mediator or expert fees, or anything that was accumulated during the pendency of the divorce. There could be wills or trusts that need to be established uh, or need to be terminated. Uh, as I said, the change of name, the restoration of the name have all different Sometimes kids will change their names, not often, but that can also be um, done and accomplished through a divorce judgment. There can be an anti-bankruptcy and indemnification provision, which means that if one party were to file for bankruptcy, their child support obligation would not be extinguished. There can be a statement of agreement that there's been a full disclosure of assets. There can be a statement about conveyance of property and how that's going to be accomplished, if they're going to sign a quitclaim deed or some other manner. Uh, they also can be a provision about a mutual release um, of, of, you know, obligations between the two parties. The, there can be a provision about the court continuing jurisdiction, which means the court would continue to have power to enforce the judgment. So that kind of language can be in there. If the parties have opted out of using the friend of the court, that has to be in there, and we have other documents that also need to be filed. And so you can be as creative or not in your judgment of divorce. The more detailed it is, the easier it is to enforce, but it may be harder to modify. It just depends what is being sought. The way that that judgments of divorce are enforced is either by filing a motion to enforce a judgment, which requires 7 days notice, and the relief that is being sought is for the court uh, to tell the other party, you must do it. This is what the judgment says, and if you don't, blah 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 is going to happen to you. Or not only are you going to do this, but you're going to do that too. Um, the second the second way is to do a motion in order to show cause, and in that proceeding, you're asking the judge to hold the other party in contempt if they are unable to show cause for violating the order. And so that is a more complex procedure. The person's entitled to 21 days notice, and and that can actually be a hearing with witnesses, or it may just be the parties being sworn in to give testimony. We talked about qualified domestic relations orders. There's usually a time frame when that should be completed and filed with the court. That is best practice. It's not required, but certainly I've had people come to me after they've been divorced for like 3 or 4 years and are ready to draw on the money, and their rights were never asserted and the quadro wasn't done. And then there's law is has very limited circumstances that we can go back into court and ask for the relief and to have this quadro uh, drawn up later. And it also depends on the rules of the individual plan as well. So, just a couple of final thoughts. This is like the checklist to make sure that your attorney did everything they're supposed to do. You have a signed judgment of divorce. That means it's signed by the court and by the parties and by the attorneys if it's a consent judgment of divorce. Have any quitclaim deeds that uh, are going to change ownership of property been signed and recorded with the Register of Deeds? Does the judgment need to be recorded at the Register of Deeds in lieu of a quitclaim deed? Are there any titles to any property, cars, motorcycles, boats, snowmobiles, ATVs, RVs, that need to be transferred and recorded? We have to make sure that the client understands what the quadro is, if it needs to be prepared, and what the costs will be of preparing that, and how to monitor that and stay on top of it, um, especially if the attorney has been released then it's really up to the client to make sure that that gets done. And we usually tell our clients that you know we'll be happy to put on our calendar to make sure that it's done by this date, and we'll tickle it for another day and another day, and we'll try to solve any problems. But they have to understand that they're going to be billed hourly for us to do that, and we're not going to close their file until that's all completed. And if we have to make 50 phone calls to get it completed, that's what's going to happen. And so, they do, most of the time, they want us to continue and us to take it to the end till the quadro is done. But some people are really worried about money, and that is a place that you certainly, if you're diligent and organized, you can do it yourself. Um, and the other thing that you always want to make sure is if there's any joint accounts, whether they're bank accounts or credit cards or their securities accounts, you want to make sure that the judgment of divorce says if it's going to be closed, modified, divided, equalized, and what the responsibility of each party is. So if one party is assuming all the debt, the other person should be held harmless, and that's the language that needs to be in there. And then you need to make sure that Citibank knows that the account has to be changed to look this way. And so that's really, really important. You also want to make sure that you have current statements and are able to keep track. We often put all the outstanding debt. If we have a settlement agreement, we just spell it right out what the account numbers are, what the amount at issue is, um, so that we're protecting our clients from some binge shopping the day after the judgment's entered, to make sure that our client isn't responsible for that portion if it wasn't them spending the money. So those are all really important things just to keep track of after the judgment is filed, to make sure that they occur so that you're really done. It's really unknotted. And then there are certain forms, as I mentioned, in addition to the judgment of divorce, that need to be filed with the court depending on the county. So a record of divorce is in every case, every county. But you have something called a certificate of conformity, which is something you have to file in Wayne County only. And it basically says that it's each party acknowledging that the consent judgment of divorce conforms to what they agreed to and conforms to the law. There can be direct deposit authorization forms. There's a change in personal information form that people can use to change their address or the child's address with the friend of the court. And as I mentioned, we have a uniform spousal support order and a uniform child support order that will also be entered at the same time as the judgment. It can also be an income withholding order that allows the support to be taken out of someone's paycheck and automatically be processed by MSDU, which is the Michigan Support. I'm going to goof it up. Support Division. I don't remember what the last part is, but it's MISDU. And they do all of the collection and distribution of child support for the entire state of Michigan. Everyone is given an account at MSDU, and you can go and log in and see how much support is coming in at each payment, when it's coming, and if the person doesn't have an income withholding order and the person is sending the support directly to MSDU, you can see when they've received it and how long it will take for them to process and send it out to you. So that is another thing on the follow-up to know. So that is pretty much the down and dirty of what a judgment of divorce is and how we draft them and how we try to make them as effective as we can and as definite as we can, so that we don't have to litigate interpretation of the language, because that is, very avoidable by doing it right and doing it specific and just making sure all the mandatory provisions are there and that every I is dotted that we can. So with that, I will tell you the 5 reasons uh, to not to kill your or not to harm your loved ones during quarantine. Number one, protective services workers are essential. Number two, the police are essential. Number three, jails and prisons are hotbeds of COVID-19. Number four, parents can get in trouble for kids being kids. And finally, number five, very few people, if anyone, look good in horizontal stripes. So with that, I hope that you have the most wonderful, amazing weekend. And I will see you Monday at 1 o'clock. Be healthy. Bye. Not letting me stop. Okay, well, I guess we can talk a little longer since I can't figure out how to turn it off. Where did that